So when they said what it means is, if everything South Africa says is true, all of the facts they say is true, this would potentially be a case of genocide. Since we don't know any of the facts, it satisfies our jurisdiction such that we can further investigate. In other words, they made no factual determination whatsoever because they didn't actually take any, and they didn't take any evidence, and that's not what happened. So but the danger from this to Israel is the fact that they took jurisdiction. And what this means is Israel basically needs to make reports every few months to the ICJ explaining itself. And at any point, the ICJ could say, stop. This is not a way a country can fight a war. Particularly, what is the main argument of South Africa for genocide? The main argument is that civilians have died. Now, civilians die in every war, and fewer die in this one than in any urban conflict ever fought. If the mere occurrence of civilian fatalities makes a war a genocide, then effectively all war is legal. And the only countries then that will succeed are countries that really don't care about the ICJ at all.
So Eugene, welcome to our Frank Talk, which is the podcast, the webinar series, I should say, of the International Dialogue Institute. I've got some of my fellow members with us to interview you today and to have a discussion. So Henry Erges, who is sitting in Paris, welcome Henry. Piers Ackerman, sitting in Sydney, welcome Piers. And of course, Alan Howe, sitting in Melbourne, where I am as well. So Eugene, welcome. So a lot of development in the last days of the Biden administration. You were born in the Ukraine. And so let me ask you, what do you think of this latest announcement by the Biden administration to authorize Ukraine to use long-range missiles against Russia?
I think it's welcome, but it's also perplexing. That is to say, I think if you want a country to win a war, and the official policy of the United States is that they want Ukraine to win and Russia not to win, that's the official policy. You should act consistent with that and not tie their hands behind their back. And that's what the administration's been doing. Now they have this sudden about face. And if it's okay for Ukraine to use these missiles now, wouldn't it have been better for them to use them a year ago? And the timing really seems like Biden just did not want the foreign policy headache of an angry Russia, while he was running for re-election or in office. He didn't want to deal with it. And now he could do, what he always knew to be right at the end, which is frustrating because it may be too late. I'm not a military expert, but by many accounts, it may be too late. And there are many things that are not well done by halves, right? So I understand the position. This is not our fight. Whatever Ukraine did to piss off Russia, that's their problem, and they better win by themselves. And I also understand, and I'm very sympathetic with the position, that Russian aggression is a threat to Europe and the world, and they're not going to stop with Ukraine, and we need to defend Ukraine. The position in the middle, that we don't like Russian aggression, we're going to help Ukraine, but not enough to actually have them win, is kind of the worst of both worlds, because it prolongs the war and maximizes suffering. And I think we see a commonality here with Biden's policy towards the Gaza war, which is to impose restrictions on Israel, which are not going to result in Israel outright losing, and also because Israel refuses to outright lose, but which prolongs the war and then creates additional foreign policy problems for the administration. If Biden had not stopped Israel in Rafah, the war, I think, would have been over in February and would not even have been an election issue. So this was a kind of a self-inflicted injury by the Biden administration. So we see some similarities there. I don't know that it's enough to make a difference.
Eugene, wasn't the reticence of giving those weapons to be used forward into Russia in fear of provoking Putin into a nuclear response?
That was in general provoking Putin, who does threaten a nuclear response. I'm not sure I never took that threat as very credible. Putin is not, he's not waiting for the 13th Imam. He's not a jihadi. He's not expecting 72 virgins. He likes, he likes his power and he wants to stay in it. The reason he threatens nuclear war is it's because the only thing he has to threaten, right? He does not have a particularly effective military. He can't impose economic sanctions that are meaningful on the West. But I think clearly it was enough to deter the Biden administration. Now, but by that reasoning, you might as well give him Poland, Lithuania, Latvia, etc., because he's going to threaten nuclear war on those occasions. Also, I thought it preposterous, and I think other sort of former Soviet people also thought it preposterous. He's not going to go to use nuclear war against America, which he'll lose for the Ukraine, but it was enough to deter an already timid Biden administration. And by the way, I think the proof is going to be in the next 3 months when we don't see nuclear war.
Mm-hmm.
And just additional to that, Eugene, I deal a lot with the Ukrainian population in Australia, including Stefan Romaniw, the late Stefan Romaniw, who died on June 26th. And there's real anger amongst them that the West did so little in 2014. That was a lost opportunity, wasn't it?
I was one of the few people writing about it at the time. I wrote, remember Putin hosted the Olympics in 2014. I wrote an article while occupying parts of Georgia, which were not right next door. So in 2014, 2008, when he took parts of Georgia, I think that was an even bigger missed opportunity. So clearly the West did fail, I'll say. But in honesty, Ukraine also failed very badly in 2014. And, at a certain point of failure of your allies, you can only do so much to help them. That is to say, they crumbled very fast. Their government was corrupt. Their military was corrupt. Zelensky's done a very good job of rebuilding that. Now we have something to work with. It's not clear that we really had much to work with. But clearly Putin was forgiven going forward from 2014. He was forgiven, and it was water under the bridge extremely fast. Right? There was no ICC indictments or whatever one might expect, and he was not made persona non grata, and that definitely sent a message. And just kind of returning to our core topic, one of the things I wrote is that the global obsession with the so-called Israeli occupation of Judea and Samaria is in a sense a form of moral self-exculpation, like a penance, a scapegoat, like a ritual, so that they could ignore actual occupations of Georgia, Ukraine, Abkhazia, Armenia, etc. Ignore those situations, but still feel like they're doing something good. So you create this sacrificial lamb to bear all the sins of the world upon it.
Okay, so let's close the bracket on Ukraine. And of course, Eugene, you're an expert in international law, and you're here to talk about the lawfare situation against Israel, against the prime minister. Now, the question will be what's happening to the minister of the armies, now that he's no longer there. So you have a small presentation for us. So perhaps we'll let you give us that presentation, and then we'll open for discussions.
Yeah, okay. So it's interesting, Albert. I hope I didn't misunderstand your topic. When we discussed lawfare against Israel, I thought you meant the external lawfare. There's also internal lawfare. So I'll start with the external, and then I'll actually relate it back to the internal, because they actually meet at a certain point.
Okay.
The Palestinians have a clear and explicit strategy of using international legal maneuvering in international institutions to create diplomatic pressure on Israel. They do so for a simple reason. It's the best tool they have. These are fora that are extremely sympathetic to them. They don't have to make any concessions in the process, unlike in diplomacy. And what they seek to do, just to anticipate a common question, people often say, what does it mean if one of these courts rules against Israel? What's it legally mean? these things don't really mean too much in themselves, but they then fuel a next wave of boycott resolutions at universities, allowing boycott activists to target countries and said, look, the ICJ said. Now, the ICJ has said a lot of things, and most countries don't listen. I'll just give you a little sneak peek, a data sneak peek. In ICJ provisional measures rulings, that is to say, these kind of rulings that they had against Israel, in cases involving armed conflict, compliance by countries is close to zero. That is to say, they are almost never listened to. And that's not just Russia, it's also the United States, which has been given various orders by the ICJ, which it just ignores. But because Israel is diplomatically vulnerable, the use of these institutions allows them to really create a narrative, a diplomatic narrative. And then when you come, because Israel is a sui generis case, even well-functioning international institutions, which most of them are not, become poisoned by the Palestinian issue. The Palestinian issue corrupts everything. But there are institutions which are otherwise whatever okay or fine or not inherently problematic, unlike UNRWA. There's UNRWA, which is, let's say, inherently problematic. And then there's the ICC, let's say, which is not inherently problematic, or maybe inherently useless, but not inherently problematic. And creating precedents in these fora allows them then to go to countries like Australia, which have, let's say, a respect for the rule of law, Canada, etc., and say, look what the ICC said. And unless you're truly an expert in international law, in the workings of these institutions, it will often sound much more impressive than it is. For example, one phrase I've heard a lot just in the past several months is the ICJ ruled that Israel is illegally occupying Palestine. That never happened. It never happened. What does it mean it never happened? So the ICJ did in July issue an advisory opinion. What's an advisory opinion? An advisory opinion is exactly what it sounds like. It is not a legal ruling, and it is not a ruling in the case. By the ICJ's own charter, an advisory opinion is not precedential, does not bind any parties, and is not considered a ruling in a case. You know the famous expression about opinions, right? Everybody has one. So the ICJ's opinion is not, in this sense, is not legally entitled to any greater deference. Moreover, when the ICJ decides an advisory opinion, it is acting on the request of the United Nations. Not everybody can. I can't ask the ICJ for an advisory opinion. Albert can't ask the ICJ for an advisory opinion. You have to be like the United Nations or some other official organization. And all they're doing is answering the question that they were asked. What was the question that they were asked? The question they were asked was by the General Assembly, a well-known institutionalized font of anti-Semitism. And the question that they were asked was, tell us, given that Israel is illegally occupying Palestine and doing horrible things there, what should now happen to Israel as a result? So in other words, the premise of occupation, etc., was baked into the question. They're not allowed to say, no, wrong question. They could have not answered the question at all, that would have been better, but once they're answering, they have to answer the question. So then all they discuss, they assume the premises of the question. So to the extent that they say anything about Israel is illegally occupying, they're simply using the premises of the United Nations, which is not a legal body. The General Assembly is not a legal body. Okay, for example, but that took 10 minutes to explain, so when you go to a campus and say, ICJ ruled, that's a powerful thing. Okay, so we have seen this proceed in two major fora, the ICJ and the ICC. So let's start with the ICC because it's in many ways more important. The ICC is not part of the United Nations. The ICC is a fairly recent creation. It is 20-something years old. It was created in 2001. And it is an independent, freestanding institution. In practice, it does take a lot of its guidance from the UN, which I think is contrary to its purposes and charter, but just because the people who staff these kind of institutions are all basically the same people and they go back and forth. Side note on that, but I don't want to forget, the prosecutor of the ICC now is being investigated for sexual crimes. And who did they get hired to do that? For some reason, they hired the UN's internal investigative team. That I think is a mistake because they're supposed to be independent of the UN's investigative team. But who is one of the directors of the UN's investigative team? The prosecutor's wife. So it just shows there's a lot of back and forth between these institutions. And she seems to be standing by her man. So the ICC is a freestanding court. Its job is to bring the perpetrators of the worst atrocity crimes in the world to justice. The idea it was created so after the Yugoslav and Rwandan genocides, and the Security Council created ad hoc courts, sort of courts to deal just with those specific situations. And the idea is let's have a court that's always available for these kind of mass crimes. But because it's not part of the United Nations, it does not automatically have jurisdiction over countries. Countries have to join because that's part of state sovereignty. It has jurisdiction over the territory of those countries that choose to join. Now, as you know, of course, Australia has joined, but many countries have not joined. And prominent on those lists are America and Israel, India and Pakistan, pretty much all of the Arab world, China. Most of the world's population lives in countries that have not joined the ICC. Moreover, all countries that are likely to engage in militarized conflict are not members of the ICC. Right? That is to say, the countries that join are countries that are very unlikely to engage in large-scale militarized conflict, and so unlikely to have to relate to the ICC. So the ICC has authority by virtue of countries joining and giving them authority. They don't have global jurisdiction. No such thing exists. And they're supposed to deal with the worst crimes in the world. Now, before we get to Israel, it's just worthwhile to talk about how the ICC has fared so far. So the ICC has basically been a dud. In the 23 years of its existence, it has secured final convictions, like convictions that have stood up on appeal, against guess how many people for atrocity crimes?
Zero?
No, it's more than zero.
More than zero.
4. 4. Okay. 4 is not a large number. They've gone after more, but like with little success. 4, all of them being various kinds of African warlords, obscure African warlords, from the Lords of Liberation Army and other participants in the Great African War. Now, there's a reason for this. The reason is, really, you can't have a prosecution service detached from either ex-ante law enforcement or ex-post punishment. That is to say, the reason people can be prosecuted is because police go and catch them. But the ICC doesn't have its own police. And since the people who it goes after have state power, someone has to remove that state power. Who's going to do that? So typically, the people who they manage to prosecute are all defeated leaders. Some they already lost a war, and then they happen to fall into the hands of the ICC. Or there's a coup in their country, and the next government turns them over to the ICC. They have never successfully prosecuted an incumbent head of state, and so their indictment of Benjamin Netanyahu and Gallant, who are incumbents in a democracy, which is unprecedented, really is quite extraordinary, because how are they going to get their hands on them? The same with their indictments of Hamas leadership. The ICC. So the question is, why does Israel did not join? Israel did not join for good reason. The ICC statute itself has specific provisions that were specifically inserted to target Israel. So, for example, the provision of the Geneva Convention that deals with transferring population to occupied territory was rewritten specifically by Algeria and other countries, which didn't wind up joining the court anyway, specifically to target Israel. The only country that had special provisions kind of adjusted to try to target. So Israel did not join. So if Israel did not join, how can it be investigated by the ICC? So simple. They invented a country, which they then said has joined the ICC, and then they invented borders for that country and claimed that the actions fell within the borders of that country. That is, of course, the state of Palestine. So Israel is currently, just to tell you how unique this is, Israel is the only non-member state of the ICC being investigated on behest of a member which is not a state. Right? Kosovo is not a state. Somaliland, there's no other borderline states. They made a clear exception. And when the prosecutor decided to treat Palestine as a state that can join the ICC, they said, look, we're not really saying they're a state, like an existing state. We're saying when the ICC statute says that it's only open to membership by states, it doesn't mean states in the way that states is used in the rest of international law. Again, another sui generis rule for Israel. The states just for this purpose. So they invented this state, invented its borders, and then accused Israel of crimes within those borders. Now, the crimes that Israel is being... So first of all, there's no jurisdiction. I think that's quite clear. Another reason there's no jurisdiction is the ICJ, it doesn't hear that many cases, as I mentioned, right? And there's a lot of really bad stuff happening throughout the world. So there's a built-in rule to keep the ICC from being overwhelmed by all the bad stuff in the world. Namely, it only steps in if the domestic country is unable or unwilling to prosecute crimes. In other words, when it's shielding leaders with impunity. Whatever you can say about the Israeli Attorney General, it is very hard to argue that she is shielding Netanyahu from prosecution for serious, grave crimes, because she's certainly prosecuting him for a lot of borderline and obscure and victimless crimes. Right, Israel is not a country where the Attorney General can't go after the Prime Minister because she's afraid. She's going after the Prime Minister for lots of stuff. Why is she not going after the Prime Minister for the alleged crimes? Because they're about things that never happened. That's it. So they just didn't happen. So the ICC says, oh, look, you didn't investigate. Well, of course we didn't investigate because there's nothing to investigate. So that's another reason the court should not have jurisdiction. Needless to say, they disregarded all of these rules. And what they're investigating Israel for is really quite shocking because it's something that didn't happen, like just actually didn't happen. It's not that it happened and Israel is not guilty of it. It just, in fact, didn't happen. If it did happen, Israel wouldn't be guilty of it. And if it did happen, it wouldn't be illegal. But it didn't happen. So that's what am I talking about? The central accusation is the purposeful starvation of the people of Gaza. What's the problem? They're not starving. And there had been many reports by the various UN agencies before the indictment was issued accusing Israel of starving people of Gaza. It seemed to be untrue because aid trucks have been going in continuously. More calories per person are going into Gaza now than before the war. And of course, Gaza has its own means of food production. Israel has never targeted warehouses of food or food production centers in Gaza. If you want to starve people, you're not just going to restrict food in, right? You're going to target their food. Israel has never done that. Since the ICC prosecutor issued their announcement, the same UN agency that was accusing Israel of starving the people of Gaza, or saying that starvation is imminent in Gaza, issued a revised report. I kid you not. They said, oops, it turns out we were wrong, there is no starvation. It was a mistake. We relied on bad data. The data that they principally relied on, how did they previously measure starvation in Gaza? A Palestinian survey group called up a few hundred Palestinians and said, we're doing a survey on whether Israel is starving people in Gaza. Are you starving? And a lot of them said, oh yeah, we're starving. Israel's starving us. That was how they counted. That's not a significant epidemiological, public health method of considering starvation. In fact, according to the UN, guess how many people have died of starvation in Gaza? Right? Whoever said zero, now it's your turn. Zero! 0 people have died of starvation in Gaza, according to the UN's food emergency program. So they're being indicted for something that seems not to have happened. But even if it did happen, by the way, it's not Israel's doing. Why? Because Israel lets food into Gaza. What happens to the food once it gets into Gaza is simply not Israel's responsibility or under Israel's control. Right? Israel's not administering Gaza. And we know that Hamas, in fact, diverts huge amounts of food. So, in fact, people may, in fact, be hungry and missing meals. Hamas is actually diverting the food. So, indicting Israel for the calorie intake of people in Gaza is basically ignoring the existence of Hamas. But even if Israel were blocking food to Gaza, it would be entirely legal. Why? Because siege is a legal method of warfare. What does siege mean? There is simply no legal obligation to feed your enemy. And moreover, there's no obligation to allow third parties. So the most amazing thing about this is, under international law, you're allowed to prevent third parties from delivering food to the enemy through common borders that they have. But certainly there's no obligation to allow provisions to go through your own territory to the enemy. There's simply no precedent for that in war. And it is lawful to prevent the transport of food and medical supplies to an enemy territory if the goal is to weaken the enemy fighting force. Now, there's an exception to that. Certain essential supplies have to be allowed in. They're very minimal. Basically, food for people 15 and under, and medicines and food for pregnant and nursing women. Israel has always allowed much more. But even that minimal amount is allowed to be taken away. This is under the additional protocol to the First Geneva Convention, by the way. If there is a credible fear of what's called diversion, namely that it would not go to the civilians for which it's intended, but to the opposing military. That is not just a credible fear, that's like a well-documented fact. We know Hamas gets this, so Israel's under no responsibility. So they're being indicted for something which didn't happen, wasn't Israel's fault if it happened, and would be legal even if Israel did it on purpose. The point is to delegitimize Israel. Now, of course, they also indicted 3 Hamas leaders, but this kind of demonstrates my point. The ICC can't arrest anybody who's currently in power. And I wrote at the time, and I've written numerous places, when the ICC does this thing, oh, we're indicting Hamas and Israel. It's not, in fact, even and fair, because the only effect of this is to deter the Western democracy. Why? Let's say you're a Hamas leader. Let's say you're Sinwar. When you authorize the genocide on October 7th, you know 2 things are going to happen. Well, one of 2 things are going to happen. What's going to happen? Either you win, right? They don't get you. You stay in power, in which case you are the great sheikh of the Arab peoples forever, and you enjoy massive rewards and benefits, and your name will be sung for hundreds of years. Or you lose. What happens if you lose? You're dead, right? There's no way that you're not coming. So you accept this risk. Massive rewards if you win. If you lose, you're probably dead. This is what happened to Gaddafi. This is what happened to Saddam Hussein. Gaddafi was also indicted by the ICC. Now, let's say now you introduce the possibility of ICC prosecution. When is ICC prosecution going to be a possibility? Not in the you win state. If he wins, he stays in power. Who's going to come get him? It's only possible in the you lose situation. And in the you lose situation, it actually increases your expected return. Why? Because now there's an outcome other than you're dead. Right? Sinwar would have loved to pop out of that building that he was in when he was killed and say, wait, ICC, take me. I'm indicted. Right? Fortunately, we didn't give him the chance. Wouldn't Gaddafi rather spend his last 30 years giving anti-Western speeches in The Hague than being torn to pieces by a crowd? So it only helps these dictators. Now, for Western democratic leaders, they expect to have a transition out of office at some point. And they're not doing this for their own personal power. They're doing it as elected representatives of the state. Why should they expose themselves to disproportionate risk? Right? Bibi didn't decide to, restrict goods into Gaza. That was like a completely unanimous Israeli government decision supported by the entire public. But he's the one who's going to go to jail. So it actually deters leaders like that. But he has not been much deterred, I think. But that's the only potential. So really, it just helps Hamas. That's the bottom line. Its predictable and inevitable effect is to encourage and predict and help Hamas. Okay, let us. A few other interesting details. The prosecutor knew that he was doing something very extraordinary when he brought this case, and so to cover his butt a little bit, he hired these experts. He hired these experts to investigate and recommend whether to proceed. The experts that he hired some British and one Australian, by the way, academic, were all had an open track record of pro-BDS activism. These were people who had actually called for Netanyahu to be indicted for other stuff, and Donald Trump and whatever, other people, to be previously. So they're on record as calling for sanctions against Israel, boycotts of Israel, and indictment of Israeli leaders. And then he says, can you be our neutral, impartial expert to investigate whether Israeli leaders should be indicted? Amazing, right? I'll send you a link to an article I wrote where I uncovered this. Is there a chat function? Hold on.
Yes.
I don't see it, but
There is a messaging function. Didn't we allow it? Let's have a look.
Anyway, I can send you that when it's ready. Okay, so biased prosecutors, biased experts picked by a compromised prosecutor for a court which is struggling to make its existence relevant. And frankly, it would be very nice if countries like Australia, they believe in the mission of the ICC. This is how this kind of abuse happens, right? Countries like Australia, they think the ICC is great in theory. So it gives them a lot of cover to do really bad things, because what are you going to do? Get rid of this potentially very useful thing? But that is how the Palestinian cause corrupts institutions, and it would be very useful for more serious pushback from member states like Australia, including saying things like they will not proceed. They will not. What position? The government said that they would arrest Israeli officials. Yes, did they take a position? I don't recall. Different countries said different things, but there are several countries that said we will not. This is legally worthless, and we will not arrest Israeli officials based on it. By the way, who has done the most in the world to bring to justice indictees by ICC? Israel, which killed 3 ICC all 3 of the Hamas indictees, taking them off the docket. So they deserve like a prize for international justice. The US actually has rewards for this, but is not going to pay them to Israel. Okay, now what about the ICJ? The ICJ is a different kettle of fish. It is part of the United Nations. It was created as the judicial arm of the United Nations. It also does not have much work. The idea was it would hear all these disputes between countries. Most countries do not agree to have their cases brought before the ICJ anymore. And principally, it has jurisdiction in cases where there's a treaty, and that treaty says that disputes will be decided by the ICJ. So the treaty here in question that got Israel in front of the ICJ is the Genocide Convention. So quite perversely, the convention that was passed to prevent the genocide of the Jewish people is being used in the ICJ to enable the genocide of the Jewish people by preventing the Jewish people from resisting their own genocide. Now, the Genocide Convention basically says genocide is illegal. It takes a very kind of unclear definition of genocide, which allows a lot of room for interpretation. It says genocide is killing a group in whole or part. So that could mean anything. But it's understood, of course, by its context and what it was addressing to mean really mass purposeful slaughter of a civilian population with the design to wipe them out. Now, how did this wind up in front of the ICJ? So Israel is a party to the Genocide Convention, of course. Who's not against genocide? So South Africa is also a party. So there's a provision in the ICJ Convention that says if there's a dispute about this convention, it can go to the ICJ. What that has traditionally meant is if there's 2 countries in a war and they're accusing each other of genocide, they can ask the ICJ. So there was a Serbia versus Croatia case, there's a Russia versus Ukraine case, and so forth. But here, South Africa did something tricky. They wrote a letter to Israel, to the Israeli Foreign Ministry, say, "Dear Israel, we believe you are committing genocide in Gaza." And Israel wrote back to them saying, "No, you're mistaken, we're not, let's talk about it." And then they took these 2 letters and they went to the ICJ and they say, "Look, we have a dispute about the Genocide Convention. We say they are, they say they're not." So so it's not a real dispute in a sense of legal standing, legal justiciability. But the ICJ ignored all that, as of course they would, to maximize their own power, and they took jurisdiction of this case. Now, since then, they have not done anything too terrible. That is to say, they have not, in fact, determined that Israel has committed genocide. Now, often you'll see quoted things that ICJ said there's a probable reason to believe that Israel committed genocide. It's a purely jurisdictional statement. So when the ICJ hears these cases, they don't have a method to take evidence, right? Both sides just submit papers and they come and argue, and then the ICJ decides what to do. That's at the temporary injunction kind of phase, preliminary measures as it's called. So then the ICJ just kind of makes a decision off the cuff. And the first decision they need to make is, do they have jurisdiction? Then they consider the case. How long does it take the ICJ to consider a case? Minimum 5 years. 10 is very normal. In other words, they're not really going to rule on this at any relevant time, and that's always the case with the ICJ. So when they said there's what it means is, if everything South Africa says is true, all of the facts they say is true, this would potentially be a case of genocide. Since we don't know any of the facts, it satisfies our jurisdiction such that we can further investigate. In other words, they made no factual determination whatsoever because they didn't actually take any, and they didn't take any evidence, and that's not what happened. So but the danger from this to Israel is the fact that they took jurisdiction. And what this means is, Israel basically needs to make reports every few months to the ICJ explaining itself. And at any point, the ICJ could just say, stop. This is not a way a country can fight a war. Particularly, what is the main argument of South Africa for genocide? The main argument is that civilians have died. Now, civilians die in every war, and fewer die in this one than in any urban conflict ever fought. If the mere occurrence of civilian fatalities makes a war a genocide, then effectively all war is legal. And the only countries then that will succeed are countries that really don't care about the ICJ at all. So what it effectively does is criminalize defensive war for Western democracies, countries that are likely to care. And so in effect, it enables genocide, and that's quite terrible. Now let's bring this full circle to lawfare against Israel. As we know, the Attorney General of Israel, the legal authorities of Israel, who are the real prime ministers of the country, have a very tense relationship with the nominal prime minister of the country, Benjamin Netanyahu. I say nominal because, for example, the Attorney General now is saying that she's going to remove a cabinet minister. So that's usually not the kind of thing anyone but the prime minister can do. So if you can remove a cabinet minister, you're the prime minister. So the Attorney General, the official position of Israel is that all of these investigations are baseless, there's no jurisdiction, and so forth. And that's the correct position. But after the ICC in particular issued its war indictments came out, the Attorney General started saying the following: there needs to be an official investigation of these alleged crimes to protect us from the ICC. And I think that is a completely illegitimate and catastrophic position, and actually weaponizes the ICC as a political tool against the government. Why? Because if the ICC has no jurisdiction, which is true, you don't need to do anything to satisfy them. You need to ignore them, because if you do things to satisfy them, it concedes the point that they have some authority. And if you do things to try to satisfy them, it also concedes that they are not purely a political anti-Semitic witch hunt, but that they're really like looking carefully, are you going to investigate, are you not going to investigate? It doesn't matter whether you investigate. We talked about this notion that they don't open cases against countries that have well-functioning domestic legal systems. Can I give you an example of a country that was considered to have a well enough functioning legal system to stop an ICC? Guyana, which according to the State Department Human Rights Report on it, does not actually have what you would call a legal system. But they said, someone in Guyana who calls themselves a judge says they're going to look into it, and that's good enough. The So it's not that Israel's not investigating enough; it's that there's no such thing as enough. But in a sense, the Attorney General is trying to use the threat of this court, which Israel never joined, to undemocratically pressure and investigate yet another investigation of the Prime Minister, and that would be a complete capitulation and a disaster. So far, it hasn't gotten anywhere. But we also see Israel's legal advisors, who have a lot of authority, now invoking the ICC to try to limit the army, saying, you don't want the ICC to investigate. The ICC is going to investigate. The only thing that's going to stop the ICC is sanctions from the Trump administration, which are going to happen. And then it won't investigate. But it's not about the merits. And that just shows the, I think, unscrupulousness of the Israeli domestic legal regime in their war on the Prime Minister. Okay, that was longer than I said I would talk, so I'm going to take a break.
Thank you, Eugene. That was really good. It was so good that I doubt that we have any questions about to clarify anything you said. It was very clear. But let me take a bit of it. Oh, you have one. Very good. Go ahead, Piers.
Eugene, I have one question. What's the status of Turkey having accepted the leaders of Hamas from Qatar?
Good question. Turkey is not a member of the ICC. You would not be surprised to learn. Now, interestingly, Turkey has committed significant crimes within the territory of an ICC member. Cyprus is an ICC member and has been a member since 2001. Turkey occupies 1/3 of Cyprus and is actively building settlements there and continuing to move Turkish people there. And I organized many years ago an actual complaint by Turkish Greek Cypriot refugees in Cyprus, including a member of the European Parliament, to the ICC, saying, hey, you need to investigate Turkish settlements. That was, I think, now 10 years ago. We still have not gotten an answer. 4 years ago, the outgoing prosecutor said, wait, before I leave office, I'm going to answer. And then she didn't. So the Hamas officials who are being hosted are not the ones who are indicted, because all the ones who are indicted are dead. Now, presumably, the ICC, if the ICC took its job seriously, they would also indict these people who are actually the more senior leadership of Hamas, right? In a sense, they created this false equivalency between disgusting equivalency between Sinwar and Netanyahu. The real sort of hierarchical equivalence would be between Khamenei and Netanyahu, but certainly some Hamas leader. So it does not create any immediate implications. If they don't want to leave Turkey, which is not an ICC member, they'll be fine there.
Yeah. Eugene, while there are no legal consequences for Israel, but all of that has political consequences.
Correct. That's the real point.
That's the real point, is it not? And so, especially around all the very good friends of Israel, that it has so many good friends. But talking about good friends, there is Mike Huckabee, who's going to become the new ambassador of the US to Israel. He used to be the governor of Arkansas. And if I remember, they signed a treaty, or not a treaty, but they signed a legislation against BDS. Were you involved with that?
Yeah, so Mike Huckabee is a friend of mine, and
that's where I was getting to.
We work closely together. He's a genuine supporter of Israel. So Arkansas is not unique in this. Over 30 some American states have passed laws against BDS. And I wrote most of those laws. In Arkansas, there was a lawsuit against these laws brought by the ACLU, kind of a liberal group. And the state defended the law very seriously. I also wrote a brief in that case, and we won before the Court of Appeals 9-1. But he's very committed. That's just why, I mean, those laws everybody has. His commitment goes far deeper than normal. And I think it's also very good for the first time in decades to not have a Jewish ambassador.
Okay. So I heard Mike Huckabee make some declarations, and he was speaking a little bit like yourself. So I thought that there must be a connection there. So
Yeah, we talk.
So it's not surprisingly. And so some of the points that he makes, like Judea and Samaria, are technically not occupied territory. Can you expand a little bit on that?
Okay, so it's a long story. I should say one good thing that has come out of all this ICJ thing is the advisory opinion decision had a dissenting opinion, which is the first it was a dissenting opinion, just one judge, but for the first time, any international legal judge has endorsed the specific view of the status of the territories presented by my colleague Avi Bell and I in a paper some years ago, and it was obviously influenced by our paper. I'm very glad she didn't cite our paper. That's also good. For the same reason, it's good that Mike Huckabee is not Jewish. There's several reasons why it's not occupied. But first, again, before one decides whether it's occupied, you need to know what is occupied. You need to know what is occupied. And occupation is when is a situation that arises in wartime, when one country's military takes control of territory of a hostile country and administers it as the government. So there are numerous reasons and rationales why there's not an occupation. I'm not going to go into them in depth. I'll just list them.
Sure.
One is that the territory was not Jordan's, right, or Egypt's. Israel did not take the territory of an enemy state because this territory did not belong to those states. That's one of the traditional explanations. Now, I go further and say not only did Israel not take the territory of an enemy state, this territory actually was Israeli sovereign territory, unlawfully occupied by Jordan. What do I mean by this? There's a doctrine of international law to determine the borders of new countries. What are the borders of new countries? They're the borders of the previous administrative unit. So in other words, the borders of Syria are the mandate of Syria. The borders of Togo are the mandate of Togo, and the borders of all the new Asian countries are just basically the previous colonial boundaries. Yes, those boundaries were all unfair, but if you don't stick with them, then everything comes into question. Right? That's how so for example, why do we think, let me take an example, why does everyone think that Crimea belongs to Ukraine? Is it because the people there are Ukrainian? No, mostly they weren't. Is it because it was historically part of Ukraine? No, it only became part of Ukraine when Nikita Khrushchev redrew the borders in the 1950s. The only reason to consider it part of Ukraine.
But Crimea was declared a republic, if I recall. In the early 90s, it became a republic. It had its own constitution, its own prime minister, and it was taken over by Ukraine. So there is another nuance there in Crimea, is it not?
So Crimea was an autonomous region within Ukraine.
It has its own constitution and prime minister.
Not prime minister. No, it had internal autonomy. It then claimed to secede as part of the Russian invasion. But when Ukraine became independent, Crimea was within the former Ukrainian Soviet Socialist Republic. And what that means is, under international law, under this doctrine, it's Ukrainian territory. Doesn't matter how it became part of the Ukrainian Socialist Republic, why, what, period. Otherwise, all new countries have all of their borders permanently in dispute. Because everything was done arbitrarily by some colonial or other power at some point.
No, I understand your point, but the point also is that at the same time, when the Soviet Union broke out and Ukraine became independent after the Soviet Union, after the wall of the Berlin Wall fell, because, we are old enough to remember the news, because the news were there for everybody to see. And Crimea became also an independent state. So how is it that Crimea suddenly comes under the Ukraine? I have not been able to find the answer to that question, but I'm sure I missed a piece of news.
Yes, okay. So I think you're mistaken, basically. Crimea always had autonomous status. And it preserved that autonomous status in Ukrainian independence, but was never regarded and never declared itself an independent state until Russia interfered in 2014. It's a similar story, kind of, with your story is closer to the story of Nagorno-Karabakh. Nagorno-Karabakh was an autonomous Armenian region within the Azerbaijani Soviet Socialist Republic.
I
And
promise
they
you,
did
I draw this purely from my memory of the news of the time.
Yeah, so they did not become Nagorno-Karabakh because they did not want to be with the Azerbaijanis. Russians and Ukrainians aren't too different. They didn't care about being together. But the Armenians in Nagorno-Karabakh, which was an autonomous entity within Azerbaijan, they did declare independence and basically tried to join Armenia, and they fought a war that they won.
Mm-hmm.
Now, just last year, by the way, this is the best proof of my theory. Last year, Azerbaijan retook Nagorno-Karabakh. And not a single country in the world objects. Why not? Because it was within the borders of the Azerbaijani Soviet Socialist Republic. That means it's now within Azerbaijan. What kind of autonomy they have is a separate question. But they're not a separate country. Exact same principle means the borders of Israel at the moment of its independence, which is when this is determined, is the borders of the British Mandate. Now, it's true that various Arab countries invaded and occupied part of that territory. But that doesn't change the territory. And what this means is, just like when Azerbaijan 2 years ago retook Karabakh, no one considers it an occupation because it was always part of its territory from independence, even though they never controlled it. And they waited 20 years to retake it. When Israel retook Judea and Samaria and Gaza, they were simply retaking their territory, ending occupation rather than starting. So that's reason 2. And that's what was endorsed by the dissenting opinion in the ICJ case. Reason 3, if you read one of the original sources for this idea that Israel is an occupying power, it's an opinion by the State Department legal advisor, Herbert Hansel, in 1977 to Jimmy Carter. And he says the following. He says, he does not address the 2 arguments I made for why it's not an occupation. He just says it's an occupation. And then he says, of course, occupation can only exist in wartime. If Israel were ever to make peace with Jordan, for example, the state of occupation would end. Now, he wrote that in 1977. He probably never thought it would happen, so it's like an easy concession to make. Mm-hmm. 1994, Israel makes peace with Jordan. There's no other example of an occupation being considered to exist after a peace treaty with the country, the war with which supposedly started the occupation. So that's why there's no occupation. Those are 3 reasons.
Okay, very good. Henry?
Well, first of all, Eugene, thank you very much for that really extraordinary and very enlightening presentation. I certainly wouldn't claim to be an expert on either the ICC or the ICJ, but having had to read about them recently, I've had to obviously try to learn a bit about them, and even so, you've added an enormous amount to what I know about those institutions. I have one specific question on the ICJ and on what you said about the ICJ, and then a broader question. My question about the ICJ is the following, and it's really in respect of the Genocide Convention. Now, as I understand it, one important element in the jurisprudence with respect to the Genocide Convention is that genocide is a crime of specific intent. In other words, that you have to show that there was the intention specifically to commit genocide, that is, to annihilate or exterminate or destroy a particular human grouping. And what the ICJ has, as I understand it, said in the past is that where there isn't direct evidence of that intention, then it will only infer that genocide has been committed. And this, I believe, was also consistent with decisions in the special tribunals. it will only infer that genocide has been committed if that is the only plausible explanation that is open to it of the relevant conduct. And that's obviously quite significant because it creates a delineation between acts of war as such and genocide. Now, Ireland has recently submitted to the ICJ that it revisit that approach and that it open up the grounds on which it is willing to find that genocide has been committed to any situation where genocide could be one of the motives of the conduct and not necessarily the only explicable motive of the conduct. Do you think that's a real risk? Is it likely that the ICJ would, in effect, change its entire jurisprudence with respect to the crime of genocide so as to find genocide with respect to the alleged events in Gaza? And doesn't that have broader implications? My second comment, if I just, not a comment, but a second is an additional question, if I may, and I realize I'm abusing of your time, so my apologies. But it seems to me from everything you say that one of the most important implications of it is really the following. We hear a great deal, particularly from the Australian government, of the importance of preserving a rules-based international order. Isn't the problem at the moment that the rules-based international order has degenerated, at least in parts, to such an extent that preserving it and defending it is exactly the wrong thing to do? What the priority should be is to reform it in depth and make it an order worth preserving.
Okay, so let me take the first two. First of all, they would absolutely change their entire jurisprudence. I mean, the ICC invented a country and invented a meaning for the word state in their treaty, and invented, changed a huge number of jurisdictional doctrines just to deal with Israel. And the worst thing is, when you're talking about rules-based order, the reason they would feel free to change the rules for Israel is they would not feel compelled to stick to those changed rules in any other case. In other words, the story of all of these institutions is a sui generis approach to Israel. So either it will lead them to come up with new and bad rules. Like, that is to say, why is the fact that Ireland's saying this now? They've had 70 years to think about the intent for genocide. Only when the Jews are defending themselves, they have a new insight into what the intent for genocide. I posted in the WhatsApp chat group, by the way. What they've been trying to do so far is use statements by Israeli politicians on October 8th, 9th, and 10th, which, again, they only look bad if you know nothing about the world or what politicians say the day after their country is subject to a vicious attack, kidnapping, rape spree. In fact, if you look at what American politicians were saying after Pearl Harbor, it was so much worse. And you can only admire the restraint of Joe Biden, by the way, once said about a war, if the enemy, doesn't agree to listen to us, nothing is off the table about the bombing campaign against Serbia. Sounds maybe he meant genocide is not off the table. So they will for sure corrupt the rules. Now, to turn to your broader question, what you say is exactly the essence of the problem. Australia believes in a rules-based international order. I think it's nice to the extent one can have it. The problem is that the belief that many Western liberal countries have in this, or at least the cosmopolitan elites of Western liberal countries, is what I could only describe as a religious belief. That is to say, it is not a practical belief. It sounds like a good thing. We'll have the rules-based order if it works. If not, it not. It is a kind of eschatological, millennial, cosmopolitan belief that seeks to replace self-interested national governments with some kind of imagined global bureaucracy of technocratic do-gooders who have no politics, no passions, and no attachments. These people do not exist because it turns out everybody's an anti-Semite. So you can't find the, totally disinterested. They might not like their country that they come from, but they don't like Israel either. But listen, the ICC is fine if they would just stick to, basic things. And part of the problem is when you have this religious belief and you're confronted with what I would call failure of your Messiah, there's two reactions, right? Reform your institution, update your beliefs, or double down and sort of say, no, he's coming, the Messiah's coming, it's okay, it's going to be okay. The ICC has not brought us towards, So the question is, has the ICC helped prevent impunity? Does it make leaders afraid of atrocities? It doesn't seem so. So the most they're going to do is make Western democratic leaders afraid of defending their countries. So I think if Australia believes in a rules-based world order, it should be protesting to the ICC, say, hey, you're letting this one issue wreck your institution. But what the ICC is counting on is that the religious attachment of official governments like Australia to their mission, it's basically like, I don't want to use a particular religious example. Let's say there's a sex scandal in a religious congregation, right? Which there happens to be in the ICC. Like, is the message, hey, okay, we're also fallible and we need to reform? Or is it, don't talk about this because you're going to prevent us from serving our holy mission? And that, and that's the approach of the ICC. You can't point out our weaknesses because then you're on the side of the war criminals. And then it's not surprising that they are spending $300 million a year to put an average of 0 people a year in jail. It's a nice job. 300 million is their budget. I bet that is
Eugene,
bigger than the prosecution budget of Sydney.
Eugene, the International Court of Justice sounds like a good idea. Isn't the problem really the 15 judges and how they're chosen, and also the length of tenure, that they're there for 9 years at a time?
First of all, the way they're chosen is terrible. They're chosen by the General Assembly, which means you're going to have basically an institution that reflects the middle position of the General Assembly, which is, pro-dictatorship and anti-Semitic. Now, when you say it sounds like a good idea, I don't know why it sounds like a good idea. It's good for countries to have a place to go to resolve their disputes if they agree to have them resolved. But it doesn't have to be the ICJ. There's another institution called the Permanent Court of International Arbitration, which is also in The Hague, and it functions perfectly well, and it's not politicized, and it's not connected to the UN. Countries just pick their own arbitrators directly, and that's perfectly fine also. That is to say, it doesn't need to be this institution, and it doesn't need to be a UN institution. There's plenty of ad hoc international arbitration. There's other institutions, other international tribunals that are much less politicized, like the International Tribunal for the Law of the Sea, and the dispute resolution mechanisms under the WTO. And the point is, no court is going to bring justice because no court has enforcement powers. The ICJ only works when either the countries truly want it to work or when one of the countries is diplomatically weak.
Great. Piers, do you have any other comment or question?
No, I just think it's a fantastic exposition, and it's reinforced everything that I thought about the ICJ and the ICC. It's a bit like the story which was repeated this week about the number of Australian judges who are still sitting on the court in Hong Kong. I mean, the morality of these people, like those who sit on the ICC and the ICJ, it's got to be highly questioned. I've always looked at the reference by South Africa of Israel to the ICC as similar to that of Iran fronting the Human Rights Council at the UN.
And by the way, Iran has also brought several cases against America in the ICJ, usually with good success. And when I mention America, ignores the rulings. So if you remember the tanker war in the 1980s, ICJ told them the tanker war, when America was escorting ships through the Persian Gulf because Iran was firing Silkworm missiles at them.
Oh, yes, yes.
So Iran, it's called the oil platforms case. Iran went and said, America's attacking our oil platforms, which were, of course, Revolutionary Guard bases. And the
Yeah.
ICJ said, America, you must stop it. And America said, come make us. Similarly, there was another case, Nicaragua versus United States, when the ICJ ruled that America must stop fighting the Sandinistas in Nicaragua. And America said, no, and that was it. So I want to just take a few minutes at the end. My voice is kind of going here, but one final issue is the lawfare by weaponizing foreign sanctions mechanisms. And in America, far left groups have succeeded in getting sanctions that have been used traditionally against terrorist entities, rogue states, and drug traffickers for the first time to be used against a democratic ally. And the sort of marketing behind these sanctions is violent settlers. Now, in fact, I've looked into this quite deeply. For the people typically sanctioned, there is no serious evidence of violence. That is to say, all of the allegations are based solely on reports from very, very problematic. When I say far left, I mean, it's not even far left. Dawn MENA. Dawn MENA is the group founded by Jamal Khashoggi, the Iranian operative who the Saudis put through a wood chipper, and now run by Sarah Leah Winston, the former Middle East director of Human Rights Watch. They're as bad as can be. They're one of the leading forces for this. Peace Now, J Street, and B'Tselem submit reports to the United Nations based entirely on uncorroborated allegations by Palestinians. And then the United States just takes those as true. Now, the allegations, by the way, are usually not even allegations of violence. That is to say, they say violence. But when you dig down, what kind of violence are they typically alleging? Sheep scaring. I kid you not, sheep scare. So what in fact is going on is there's a lot of government land in the West Bank, and you have Jewish farmers and Palestinian farmers who are having very biblical disputes over it because none of them actually own it. Like in Australia, right? Most land is not owned. Same here.
Well, it is. It's all owned by Aboriginals. But it's a good thing that you don't have a New Zealand judge taking this case, because sheep scaring would be a very, very serious crime.
Very serious crime.
So when the sheep come onto the Jewish grazing lands, they say, get away. And then they take pictures of the guys. Anyway, that's actually what some of these cases are. But yesterday, the Biden administration went further. They're using it as a tool against political enemies. One of the organizations that was sanctioned was an organization that conducted protests of delivery of humanitarian supplies to Gaza on the grounds that much of it winds up in Hamas, which is true, which is not. That organization was sanctioned for holding protests. Yesterday, a construction company that builds houses for Jews in Judea and Samaria was sanctioned. What's the basis of the sanctions? They build houses for Jews. Some of those Jews might in the future go and commit crimes against Palestinians. What that means is they're essentially sanctioning Jewish life in Judea and Samaria completely and saying this is an area where... Now, the reason I'm bringing this up with you is because Trump is going to get rid of these sanctions in America. But what Biden succeeded in doing is having some other countries piggyback and impose similar sanctions regimes. And Australia is one of those countries. They have not gone as far as Canada, which has gone quite far in this way. But you need the courage to look past the label, right? So they sanction people at first with like big payas and big keepers, and they look very, different from you and me. And they said they're engaged in violence. But you need to dig down and say, what is the evidence of this violence? What is the violence there? Was this violence self-defense? The United Nations database that the US at least relies on its evidence, and I'm quite sure Australia does not have its own evidence, that they're just using the same thing, classifies incidents in which Jews are attacked by Palestinian terrorists and defend themselves, or the army shoots the terrorist, as settler violence. So this needs to be addressed now in Australia also. Henry.
And it sounds, Eugene, it sounds like the last days of the Biden administration is very similar to the last days of the Obama administration.
Yes.
Maybe
They're
run
going
by
outswing.
maybe run by the same people as well. Last question, I'm going to give the floor to Henry.
Thank you.
That's very interesting, Eugene, because to be honest, I haven't seen it explained quite so clearly, and I was very puzzled by what was going on in respect of those sanctions. My question is very specific. In the United States, when those sanctions are imposed, is there any mechanism of legal redress? And if not, why not?
There is one main mechanism for legal redress, and that is to ask the government entity that administers the sanctions to reconsider. That is a very difficult process because you don't get to know the evidence used against you. Again, it's designed to be dealing with like Russian dictators. First of all, it's a very expensive process. You need to hire lawyers, etc. So for like a Russian oligarch, it's not a big deal because even if you froze one bank account, he thought ahead and he has another bank account. These guys, and I'm representing some of them, they don't have another bank account. It's really, they're sheep and like, $10,000 in the bank is what they have. So it's very difficult. Now, I'm working with a group of lawyers that has filed a lawsuit in America on behalf not of people who have been sanctioned, but Jewish and pro-Israel charities that are saying that this is discriminatory and really designed to chill donations by those charities. And I will, in coming weeks, be filing a lawsuit on behalf of a couple of people who were sanctioned because they're American citizens. American citizens have much greater rights to access to American courts. But foreigners don't really have rights in American courts, like the government can do anything to them. They don't really have constitutional rights. I think that's a good thing. But in this case, it makes those challenges difficult. Now, I'm sure Australia has a similar mechanism to ask for delisting, but it's a long and difficult mechanism. And to have to do that in Australia and Canada and the UK is really, beyond the resources that, I'm not charging them, but I can't do this like in 5 different countries. Beyond the resources any of us can muster. And I think the real argument needs to be, look, so for example, one of the guys I'm representing, he has a very lengthy police record in the sense of many accusations are made against him by these left-wing groups that go and try to provoke incidents and take pictures. Each one, the police investigates, dismisses, investigates, dismisses. Lack of evidence, lack of evidence, lack of evidence, lack of evidence. I doubt that Australia has dug up something that the Israeli police have not. And again, the Israeli legal system is not on the side of the settlers, if anything, the opposite. There's just no evidence.
Very good. Eugene, we're going to leave it there. I want to thank you for a very clear talk and very informative. All my colleagues are joining me to thank you warmly. Thank you, everyone, and we will see you soon, probably next Tuesday.
Okay, thank you. And if you guys have any questions, feel free to contact me if you're ever writing or speaking.
We are always in communication.
Absolutely.
Thank you all.
Thank you, Eugene. Thank you. Thank you,
Thank you.
Albert.